everyone. My name is Alex Herwood. I'm a solicitor and head of employment at Bayani Law. And today's HR exchange is about mediation in the workplace. So I'm joined by Margaret Renshaw, who's a senior HR consultant from Make UK and a certified qualified mediator. And she will be giving us an overview of mediation in the workplace. I will then conclude the session with a little bit about judicial mediation. Right then. So just one thing to say is just, so obviously this is a webinar, so we're unable to answer questions as we're going through, but if you do have any questions, please feel free to put them in the chat box. My colleague Alice will attend to them and hopefully we'll be able to answer as many questions as we can at the end. Right then, Margaret, I'm going to pass over to you, if that's okay, to give us an overview of mediation in the workplace. Thank you.
Lovely. Thanks, Alex. Okay, hi, good afternoon. Today I want to invite you to reimagine conflict in your workplace, not as a threat, but as an opportunity for transformation. Every disagreement has the potential to reveal neglected issues, hidden talents, and new ways to grow as a team. Our focus today is on mediation, which is a structured, empowering process that turns workplace challenges into opportunities for resolution, collaboration, and growth. So, what I'd like to say there, yes, there's a reality check. Every organisation has that conflict, it's inevitable. Whether it's a miscommunication between departments or personal clashes, and they are opportunities in disguise. The thing with that is with mediation can be mediation to resolve conflict between individuals one-on-one. It can be group mediation, or it can be a wider grouping, such as department teams and interdepartmental project groups. Alex, if you'd like to move that slide deck on for me, that would be great, please. Lovely. Okay, so what is mediation and why does it work? Well, as it says there, it's voluntary, it's confidential, and where a skilled neutral facilitator helps the disputing parties understand each other's needs and work towards those mutually accepted solutions. But mediation is a voluntary process. Mediation is something that two or more parties enter into voluntarily. And it's not where an organisation thinks potentially mediation is the solution and they are trying to enforce their employees to go down that route. The other thing to mention there is it's completely confidential. It's what we call a without prejudice discussion. So it's a without prejudice process, which if the parties don't gain agreement towards the end, we're looking for resolutions here, then they can go back, they can go into the formal process within their employment sphere, and they can use the grievance procedure or aligned policies and procedures which are at the base of their complaint. Okay, so it's not deciding, again, something that was really key here, it's not deciding who's right and who's wrong. It's not like a grievance process where you have a grievance manager who makes a decision, who sits in judgment on basing on the facts, the figures, the interpretation of. This is two parties coming together and really working to gain an understanding, an in-depth understanding. My perception is my perception, your perception is your perception. So where do we meet in the middle? And it's another way to put this is it's really cathartic. It's not entered into lightly, and the parties need to be given instructions on how this works, the opportunity to understand what they're actually buying into when they start off on a process, on a journey, you could even say. Can we move it on again, please? Thank you. Okay, so we've got a mediation process. And here's a step-by-step overview of that. So mediation, there's preparation, for any mediation. And for me, I go into clients, and I could be called in to be the independent qualified mediator, so that I have no history with the individuals, I don't know them, and I sit down and I have an individual discussion. So part of that process and preparation is actually to meet with them independently. So I then understand the background, and I call this their story, their perception. What does it mean to them? And where is the pain? Where is the impact? And what are they looking for? What do they want to get out of this mediation process? For some people, it's simply being empowered by their organisation and their management teams to simply sit down in a controlled area and environment and open up, literally share what is having an impact on me, how it impacts me, what it means to me. And as I said, another phrase I like to use in these situations is getting to the heart of the matter. So delayering, unpeeling the onion and going through those processes. But if I look at this list here of mediation, this is the process whereby once you've done individual sessions and the mediator themselves, so I'll put me in that frame again, I understand, or someone in your organisation who's a trained mediator can sit down and establish the facts, establish where some of the touch points are, where some of the potential conflict comes from as well. And conflict can be, as I say, an emotional strain. It can be something that's operational. It can be something where people feel disrespected in some way. So there'll always be an opening dialogue in that meeting. And in that meeting, it will start off by I will explain the role, everybody's reasons to be there, confirm confidentiality, the fact that it's, would like it to be respectful, give people permission to share what is their honest view, where are they coming from. Once we've done that, we ask the individuals, the parties, if you like, to make an opening statement, a dialogue, and they will actually have that conversation, have that time to actually explain uninterrupted why they're there. What is it about the other party that's making them feel uncomfortable, disrespected, hurt, anxious? All those things that, you're doing a deep dive into how it really makes me feel, how it makes them feel. So they are sharing openly why they're both there and what they hopefully are looking for as a resolution or a part resolution. Now, this is not a 5-minute meeting. This can last anything from 2 hours to maybe 4 or 5 hours with recognised breaks, comfort breaks, directed by the parties themselves. But when you get into exploring those underlying interests, this is where the mediator is the facilitator. Each person is given opportunity. There should be no bias. The mediator shouldn't bring along any predetermined outcome, and they shouldn't bring with them any thoughts about where they want this to lead. They are there to use all their skills and knowledge to actually support the individuals. Yes, it's about active listening and it's empathy as well. People are comfortable, and we need the individuals to feel comfortable to be able to share. And this is where it can take time. It can be encouraging both parties to share. And you use some of that discussion that you've had on an individual basis to know where the triggers are, possibly. But again, it's not for me in my situation to say, right, you told me about X, you gave me an example of Y. I will ask the individuals to consider talking about something. Would you like to reflect? Would you like to share? What would you like to share? And again, I'll be guided by what is in their opening dialogue. So that's where the time is taken up. It's equal amounts of time, it's not showing a preference for one person. It's not looking like siding with somebody. So some of these skills And there's a pressure as well, if I'm being honest, on the mediator, the proper professional pressure to do the right thing by both parties. So you're offering that opportunity to explore underlying interests, underlying reasons why they are in that situation. We work towards a collaborative problem solving. And with that, it means that the collaboration is between the parties. I can sit there and say, well, what I think I'm hearing is you'd like to sit down and work out a plan of action. You'd like to sit down and share some of your thoughts with the individual in a workspace. How do you make it work when you go back to your desk, your place of work, etc.? And it is about the collaboration. It's about checks and balances. It's things like, is that what you mean? Is that what you act? I'm hearing, you feel hurt by this. Is that right? So guiding in the right way the individuals to have the opportunity to put their own solutions in place. What we do with that and what I would do, because there are no notes taken in a mediation process, there's no notes to be shared. I will make some notes, and my agreement with them is that once I've made my personal notes, they will be destroyed after the session. But I will make some notes when I hear people talking about potentially this could work. Maybe, maybe we approach our manager and ask to have a different way of working. This may work for us. So I'm looking to have prompts when we get to that problem solving section, with a hope that you can get something out, the individuals can get something out of it. Some employees come to this process and say, you know what, all I really wanted was some free time to have a discussion. I feel the organisation's listened to me and they've empowered us to have this conversation. They've given us time to sit down and iron out some of our problems. And it could be that there are shared issues, there could be organisational challenges and pressures that they're both feeling, and they may actually have, an agreed way. They may actually acknowledge that it's not all about them, but it's about some of the things that potentially need to change to support that improvement in that relationship. So that's the closure. And the follow-up. The follow-up is that a mediator, and I say I'm using myself as an example, will then we'll do a catch-up call with each person, given the same amount of time, ask them how they think the mediation's gone, what are their, how they're feeling now, do they believe it's been useful, can they move on using the list of collaborative problem solving into potential solutions, and where are they going to get that support? That's really important because the business is invested in the time, but that investment needs to be carried through. So once the individuals have come up with what they believe to be their solutions, then the business again needs to be invested in listening and supporting and helping, but being honest. Some people might ask for something that's just not possible and practical, but it's that honest dialogue. And that then finishes that process, unless one of the parties is not satisfied and they want to move on to following a formal process like a grievance procedure, or they've had the grievance outcome. This is why they are at mediation, and they're at a position of stay. They can't move on. So, Alex, if I can ask you, please, to move that slide on again for me, that would be great. Okay, so it's beyond the process. Let's look at it from a strategic point of view, a cultural point of view as well. As I've said, you're empowering your employees, you're enhancing innovation, because conflict, when turned around, can be constructive. It's an opportunity to look at what has happened, what potentially is happening. It can also be, you're doing a review of potential issues. It could be departmental, it could be on a particular skill set, it could be within the roles of the employees themselves. So it's wider than what do we need to do? What do we need to look at? Not from an individual basis, but from an operating basis, from an operational point of view, to do something to support. We've got great teams, give them the bandwidth, allow them that opportunity. Allow them that opportunity to be invested not only in their time and their future, but that of the organisation. What I'd like to share with you is that real world impact, but it's easier to see on the next slide. So Alice, apologies, Alex, if you'd thank you. So how do we, so can I actually get that to move back? Sorry, apologies, that's my fault. Okay, so what I'd like to ask you to look at is that world impact, okay? So consider the case in your organisation, maybe could be something that's happened, something you've dealt with in the past. You've got two departments that appear to be at loggerheads, and it's persistent. But when mediation's introduced, there's an offer of, well, okay, how do we resolve this? This is having an impact on quality, on performance. It's having a direct impact on other people. That cross-functional working, people don't want to talk to you in your team. They find it quite, there's a conflict. They find it uncomfortable. It's all those difficult conversations that people want to avoid. But when you look at that and you think of mediation, this conversation in this situation revealed that both parties were driven by the same underlying need, but they came at it from different angles. Their perception was their reality. So therefore, they perceived the other team to be wrong, inappropriate, lacking professionalism, even lacking collaboration and sharing. So by realigning their goals, not only was the conflict resolved, but they also initiated a joint project that celebrated those interdepartmental motivations and success. But these are the type of stories that underline what I would call, the transformative power of mediation. So thank you for that. Okay, again, please, if you would, Alex, that would be great. So how do we, the impact of incorporating mediation into your strategy? How do we embed it? Well, these are some hints and tips, if you like. These are takeaways. These are things that you could sit down with your own team, with your SLT, your members of your own HR department, and look at a way forward. So I would see these as things like putting it into a planning session, putting it into a visioning session or a visioning workshop. What do we need to do? Well, we need to assess the organisational need and culture, because culture is how we do things around here. What is how we're impacted and affected as well. So use the information, the data and the intelligence that you've already got and take a deep dive into that. What are the surveys saying? If you have an employee an employee works council or a works council, use them. They are there, they can be the eyes and ears. They can give you great intel about what's going on outside. Ask for their opinion. Do you think this may be something that, people would want to see? Have that opportunity to have a process to work with all those intentions. Tailor it to the mediation methods as well. It may be that, you want to start off with in-house mediators, having the mediators and volunteers trained to be in-house. They know your policies and procedures and can support that. But don't forget, there's always the potential for something where you need an independent mediator. Somewhere it could be around, issues, conflicts, disagreements of a level at senior level. So you want some independence there. You want people to feel, and the parties need to feel comfortable as well and that can be offsite, that type of thing. But once you've done that, make it clear, formulate the guidelines. So again, if that's the type of thing that you would want to explore, bring in people, use focus groups. Again, a great start is your works council, do a few pulse surveys, but define the criteria for what early intervention looks like. It could be some companies have mental health first aiders who are, very skilled. They're known for their confidentiality. That might be a starting point again for assessing, how many complaint criteria, categorization, certainly not individual cases. So if we can move on again, that would be super. Thank you. So building the capabilities, well, you've got great people in house. The people who you have got as trained investigators, managers who, are very good at interview techniques. They might actually have an interest in, diving and understanding what would be expected of them if they were to come on board and be supported in that method, in the way of making them in-house mediators. But provide the mediation training, absolutely, as it gives you a good run of who they would be. The other one is it talks about, I want to talk a little bit around, formal qualifications. There's lots of companies do workplace mediation qualifications, certificates, but also, what do you want out of it? Do you want a team who are qualified? Do you want a team who it gives them the confidence and the kudos that they're doing the right thing? You may want to build a dedicated team if you're if your site, you feel the site is big enough, you feel like you want to have 3 or 4 people. Again, you've got the scope to make it how you want it to be, as long as it fulfills that criteria of what you're trying to do. And obviously you've got your, things like your technology and your information, your databases. If we can move that on again, that would be great. Okay. But again, cultivate that proactive, collaborative culture. You want it to be open, you want it to be supportive, and you want the communication to actually mirror and match that. Encourage early voicing of the concerns in a safe, structured setting. Now, that can be with HR, that can be with, trusted colleagues, etc. But you want to start somewhere. You want to promote active listening and empathy across all levels of the organisation as well. Yes, mediation's a way forward. Mediation's a great addition to the policy, the procedure. It also gives people the opportunity to manage their own outcomes. But, it communicate the benefits of it. If you believe it's the way to go, you sign up, you champion that. And you can start small. It's the world's your oyster, however you want to do it. But for me, it's really assessing what impact it's going to have and what return on that investment it's going to give you, not only from a health and well-being, but from a productivity performance KPI route. People who attend work more frequently, people who are, working to their full potential, people who are quite open to stretching themselves with personal development aspects as well. And it just talks there about, the regularity of review. Like anything, always good if you felt as if you wanted to start this, to pilot it, have a pilot, assess, review, do a pulse survey, just see how it's landing for the wider organisation. If we can move on again, that would be smashing. Thank you. Okay. So realistically, embracing mediation for a better workplace. It does move beyond just managing disputes. It gives you that opportunity to do that. As HR professionals, sometimes, we can be seen as gatekeepers of the organisational culture, but embracing mediation transports that workplace conflict from a destructive force into a catalyst for growth, for trust and collaboration. By fostering the environment where open dialogue is encouraged, as I say, everyone feels as if they have a voice. We all have such a beautiful blend of people who come to work, our organisation, our culture, our mix. So being open to tap into all of that is a great mechanism for improvement and collaboration. If we can move that on again, thank you. I think that's the last. So thank you very much. I hope that's given you some food for thought. And I hope it's
you.
also given you some things to move on if it's something of interest to you.
Thank you so much, Barbara. That was extremely useful. A great insight into how mediation works in the workplace. So thank you so much for joining us and giving that talk.
Thanks, Alex.
Right, so now I am just going to touch upon judicial mediation. So judicial mediation is obviously something that's quite different to mediation in the workplace, in that for judicial mediation to take place, there has to be a claim that's in existence in the tribunal proceedings. So it's a tribunal-led process settling employment disputes. So what happens on the day of a judicial mediation is it's far less scary than attending a substantive final hearing. What happens is the employment judge will put on their mediator hat, act as an impartial mediator throughout the day. And this judge, if the judicial mediation doesn't bring matters to conclusion, this judge won't be allowed to be involved in the case going forward. So it's often offered in complex cases, such as your lengthy discrimination, whistleblowing, equal pay claims. Generally, what we say, yeah, sorry, Margaret, would you mind just putting yourself on mute? Would that be okay? Thank you. Just getting a bit of background. Perfect. So yeah, so offered in these complex cases for hearings that are likely to last for about 3 days or more. So often what we find is these big claims of discrimination, whistleblowing might be listed for, 8, 9, 10 days long. So what happens is this judicial mediation is offered at an early stage with a view to bringing matters to a conclusion at that early stage. It's a completely off the record, without prejudice, strictly confidential session. So you're in your judicial mediation bubble. So whatever's said within that bubble on that day can't be used later down the line. So yeah, so when and how is judicial mediation offered? So what happens is when we are in employment tribunal and we've got a claim that is proceeding towards a final hearing, we have a preliminary hearing initially, which is set down after the submission of the claim and the response. And during this preliminary hearing, the employment judge will assess whether judicial mediation is suitable. And factors that the employment judge will take into consideration are things like mainly whether the parties are willing to engage in judicial mediation. Obviously, if you've got one party who's, that's really up for it, but then you've got a claimant, for example, who just wants their day in court, their day in tribunal, and it's just simply not going to work. So both parties need to be in an agreement. It's completely voluntary. And the judge will assess whether the claim that's been before him or her is complex enough for a judicial mediation. Like I say, it's very rarely used in the kind of straightforward unfair dismissal claims. So it's usually the more juicy, legally complex claims. Usually these judicial mediation hearings will last about 1 day. And, in that 1 day, a lot can be accomplished and, the whole matter can go away. So it can be really beneficial. So on screen now, we will see a little table about kind of the various different types of mediation and at what stage we find it, or what stage we can access it. So with judicial mediation, obviously you can see from the table that this only becomes available once we've got that ET1 in the employment tribunal system. So it's post-employment tribunal. It carries a high legal weight in that it's going to be an employment judge, obviously, that's going to be overseeing the judicial mediation session, albeit with their mediator's hat on. So that employment judge has a wealth of employment law experience naturally because of where they are. Um, so yeah, so it's semi-formal, but it's not as formal as if you go to, for example, the final hearing. On the other end of the scale, we've got ACAS early conciliation, which a lot of you may be familiar with. Very informal, low legal weight, in that it's just advisory, it's not judicial. This comes before the employment tribunal claim is issued. So it's a process, obviously, that we have to go through before, or the claimant has to go through before they submit a claim in the employment tribunal. And then we have private mediation, which Margaret has spoken about this morning, which sits somewhere in between. So yeah. So the mediation session and what to expect then. Okay, so we've submitted a claim or we've received a claim if we're for the employer. And we've got a preliminary hearing that's been set down. It's been decided that the claim is suitable for judicial mediation. What then happens is that the claimant will provide or draft a schedule of loss, setting out what they would like in an ideal situation in terms of compensation. The respondent will then submit a counter schedule of loss, and both parties will set out their statement of expectations. So, what position statements? What is it they want from the day? The parties will attend on the day, and it really is, far less formal than when you go to a final hearing. The judge will start by, so we'll have claimant in one room, respondent in one room, and the judge will start by coming to the claimant and just hearing what they have to say, hearing their case, and asking them what their first offer is. And then the judge will kind of do some toing and froing between the parties in an attempt to bring the matter to a close. Now, the judge won't provide any legal advice as such. If the parties agree, they can offer a non-binding view on prospects, but obviously this has to be something that both parties want. This view that's offered by the judge won't influence the outcome of any if it proceeds. Obviously, there are the ground rules as well that the parties have to follow, and it's helpful that the judge is there to enforce those and make sure that those rules are abided by. Okay, so this is important for obviously for businesses and HR professionals. And why would we use judicial mediation? What's in it for us? Why would we choose it? And I think the main thing for us here is the significant cost saving that it can assist with. So, for example, when you have a claim that's landed on your desk, say you are the employer, and it's again this lengthy claim of or this complex claim of discrimination and whistleblowing. It's been listed for a final hearing. It's got a 10-day final hearing. It's not until, 2027 or something. And you've got to think about the amount of time cost that you're going to have to put into that case. In terms of representations, witness times, management hours, all those, keeping any witnesses that you're intending to call, taking them out of the workplace, etc. So with a judicial mediation, because it's offered so early on in the proceedings, it really does save so much time and cost and stress. It's not nice when you're a claimant going through it, or when you're an employer and you've had this claim land on your desk. It can be very hurtful. It can be just very distressing. Everybody wants it just to go away, and this is an ideal way to make that happen. Also importantly, this avoids the publicity and reputational damage from a public hearing. We know, don't we, that if a claim proceeds and careers all the way towards a final hearing, we find ourselves in an employment tribunal, we may absolutely not agree with the claim that's being brought against us. But if there's always that litigation risk, and if we lose, that judgment is going to be in the public domain. So it really helps to improve the chances of confidentiality. And it can, in certain circumstances, in theory, preserve relationships. But it also, and I feel this is always something that employers will they'll usually want, is that if they go to this judicial mediation, and let's say this employee is still in employment, nobody really knows what they're doing. Employer doesn't really know what to do with them. Claimants on the sick. You just need an end to it all for everybody. It allows for that managed exit, so that can be one of the terms. Also importantly is that when we go to employment, when we go all the way to the substantive, the final hearing, the judge is limited in what they can award. However, for example, with compensation, they can't award, for example, an apology. They can't be creative. But with a judicial mediation, the claimant is allowed in their statement of expectations, in their position statement, to set out the terms that they might like. So that might be, they want the respondent to make a charitable donation. They want 12 months private health care. They want an apology. They want, a really super duper reference. All these things can be negotiated on the day. So I always think that's a real benefit of going to judicial mediation. Obviously, another benefit is that one of the outcomes is the claim will be withdrawn. So that's it. End of matter. Put the matter to bed, and we sign these agreed settlement wording or COT3 wording. So we would agree terms on the day. Very occasionally that can't be done in the day, and it spills over maybe into the following week. But the employer will be very, I imagine, in most situations, and certainly the situations that I've been involved in, the employer just wants that closure that day, so will insist that it has to be resolved that day, because once you've lost that opportunity, once you leave that judicial mediation bubble, life goes on, and it might never happen. So that's often something that the employer will want. Okay, so here we've just set out a case study as to give you an example of how this can work. So the claimant is a senior sales manager, and they filed a sex discrimination claim, so a complex discrimination claim and a constructive dismissal claim. And the claimant has valued their claim at over £200,000. All right, we see that it's a complex claim. It's gone to its preliminary hearing. At the preliminary hearing, the judge has agreed that judicial mediation would be sensible. And it's set down for the judicial mediation, and the day is overseen by this employment judge with his mediator or her mediator hat on. It lasts a day. It's a very successful day. The claimant comes out with 45,000 as an ex gratia payment. We also get those other terms included in the settlement, which we might not necessarily get at the final hearing. For example, joint statement to staff. We've got our non-disparagement clause, so making sure that neither party says anything derogatory or defamatory about the other side. And we have an agreed internal announcement. But the point here is, we've got, if you think about this claim that's been submitted, we've got potentially 12 months to wait until it actually, maybe even more. Sometimes, down south, we're seeing claims not coming to fruition until 24 months down the line. It's just, there's a huge backlog. So there's a real push at the minute on judicial mediation. It's becoming more and more common. It has been around for about 10 years, but we're seeing a real push on it, because it just seems a really sensible way to reduce those number of claims coming through. But in a nutshell, we look at the savings for the parties. So we're looking at a significant saving in legal fees, where the matter is put to bed, and we haven't got that hanging over us for the foreseeable. So just really, really important to bear in mind. I also thought it might be helpful just to touch upon a case that I was working on recently, whereby it was again a very complex claim of whistleblowing and discrimination. Claimant had submitted this claim. We'd gone to the prelim. There was a lot of different detriments that we were relying on, a lot of different acts of discrimination that were being relied upon. Both parties agreed, so claimant's still employed. Both parties agreed, right, okay, this is a good one this would be a good chance for us to get our heads together and try and resolve this matter. Claimant's on the sick, so respondent doesn't really know what to do, for fear of, being accused of further victimization. Claimant does their schedule of loss, respondent does their counter schedule of loss, and both parties do their statement of expectations. As it happened, we were absolutely poles apart in terms of what the claimant wanted and what the respondent thought was reasonable. day before, we got a notification from the Employment Tribunal to say that the judicial mediation had been postponed. Obviously, everybody was very disappointed. The claimant was naturally very distressed by this. But because on this occasion we had counsel and we had legal reps, I suppose we took the initiative to hold our own mediation, to use that day for trying to try and resolve the matter, despite the fact that the judge wasn't there. So it was a bit of trial and error, but because we had legal reps, because we had experienced barristers, we were able to do that, and we just did our own, and it was really effective. We managed to settle the matter, and both parties came away probably feeling a little bit stung, because that's what we expect from a good settlement. A fair settlement is that one that stings both parties, but it was a fair settlement. And now that hearing, which was due to take place, I think, back in the next year, has been vacated, no longer in the list, and claimant can move on with their job. So that was a successful day for both parties. So just to summarise here with some common misunderstandings about judicial mediation. Often employers will think, well, no, we can't possibly enter into judicial mediation because that's us just, accepting that we've done something wrong, that's all our fault. It's not at all like that. If anything, it's a very commercially sound decision to make, because it's putting to bed the matter. And like I just said previously, even though we're poles apart, it's still possible to achieve an outcome, a successful outcome. So I don't agree. It's entirely false to suggest that it means they're accepting fault. This is an extremely confidential situation, so nothing can be used at any point later down the line. Only useful for high value claims. Yes, normally it is a lot of it that, we do see a lot of high value claims coming through for judicial mediation, but it's not necessarily those. If both parties think it's going to be an effective way of resolving the matter, the judge will be open to hearing that. It's saving time, it's cost, and saving that disruption to your business. And finally, we lose control over the process. Again, this is completely inaccurate. The outcome, as we've just talked about, is it's completely, the whole process is completely voluntary. You don't have to agree to anything on that day. You can withdraw if you feel it's too much, if you feel like they're not getting anywhere, we can call it a day. But ultimately, the control still remains with the parties. It's not like in a final hearing where the judge is saying, like, this is what I found, and this is what the judgment is. It's completely different to that. So that just gives you a brief overview on judicial mediation. So that was it from me. I want to pass it back to you guys. I don't know whether anybody has got any questions. Alice will have been monitoring those in the chat box. Oops, let's just go back. Let's see if there's anything else. Forgive me. Oh dear. Let's have a look. Right, so chats, have we got any? No. Okay, no questions at the minute. So as you can see on screen, oh dearie me, we're going back. Let's go back to where we were. So there's a little bit of information here about the watertight packages that we offer at Bayani Law. If you want further information on that, please just get in contact with us. We'd be more than happy to provide that. This just gives on screen now, you'll just see an overview of the training and events that we are doing that are upcoming. So we can see that on the 10th of September, we've got another HR exchange. This one is a really juicy, important one. It's to do with getting to grips with family leave. Obviously, we know that there are so many changes coming in employment law with the Employment Rights Bill. It's really important that we get on top of that. So please feel free to register. It's free by booking via hello@bayanilaw.co.uk or through Eventbrite. On the 15th of October, we've got the HR Exchange meetup. This is about culture and company values and shaping the vision and mission of your organisation. Again, completely free, and please feel free to sign up. And then on the 19th of November, we've got another HR Exchange set, and this is in relation to securing the future. So we talk about AI and cybersecurity and the HR connection. So those are the upcoming events. Please get in contact and book on those if you feel they will be helpful. So We often get asked for a copy of the slides. I'm more than happy to send out these slides to those who request it. However, we just ask that you complete a feedback form, which will be sent after the webinar. And once you've done that, you'll get a copy of our slides. It doesn't take very long at all. And then finally, if you don't already, please feel free to sign up to our HR and Employment Law monthly newsletter by clicking or scanning the QR code that you see on screen. This is a really informative newsletter that goes around, tells you a bit about what we're doing in the firm, and any hot topics at that moment in time. So yes. So thank you all so much for attending today. We really appreciate it. We hope you found it helpful. Margaret, thank you so much for joining us. It was really, really great to hear from you. So we really appreciate that. If you want to get in contact with us, please have a look at the contact details on screen now. And we'll look forward to seeing some of you at our next event. All right. Thank you all.